partner at Reddy Newman Brown PC, coming to you live from Houston, Texas, with the latest immigration update. And with me today is Stephen Brown, also a partner here at Reddy Newman Brown. Stephen, what do we have on tap for today?
Yeah, boring week for the last week of immigration, right? We're going to talk about the USCIS Adjustment of Status memo that came out on Friday. We're going to talk about some of the H-1B statistics that USCIS published. Not all of them, but some of them. We'll talk about the mandatory e-filing that might be coming up for USCIS. And then last but not least, late breaking news today about Department of State announcing that that they've used all the India EB2 inventory for the year.
All right. So this policy memo that gets dropped on Friday of a holiday weekend about adjustment of status, saying that it's a matter of discretion and that normally the process is to consular process, and doing the adjustment of status while you stay in the US is an extraordinary form of relief and requires a matter of grace, and it is the long-standing way to receive a green card through the process. Do you agree with all of those statements?
No, not at all. I mean, I do agree that adjustment of status is discretionary, but I did a little research today, Emily, and this weekend, and I was a little curious about the history of this. So, give everybody a little history lesson. 1924 is the first time Congress recognizes the difference between people coming in temporarily and permanently. 1940 Alien Registration Act. That's the first that led to the green cards we have today. They got a separate registration document to distinguish them. 1952 is our first Immigration and Nationality Act. Congress says in there, we're going to allow this adjustment of status idea. And since then, we've had multiple statutes, Emily, that have supported the idea. We have 204J with flexibility for long delayed adjustment of status applications. What we all know as Supplement J. The EB5 Integrity Act of 2022 allows for concurrent filing of I-526 and I-485, which means, and there's a ton of others. And so we can see that over the last 70 years, Congress is working towards making adjustment of status easier rather than harder. So maybe Joseph Edler is looking at something differently than I am, but I see, 70 plus years of congressional history that this is the way it's intended. Yes, it's discretionary, but it's certainly not this tradition of Congress that we don't adjust, and that's an extraordinary remedy. I don't know where that's coming from.
Yeah, I also find it funny. So you mentioned 204J, so that's AC 21. The whole point of AC 21 was to help our workforce become more competitive by allowing flexibility for foreign workers, who have long pending adjustment of status applications, long pending green card applications waiting in the backlog. So that's kind of the background that we've had going on since 2000. And then in 2017, DHS's own regulation was titled Retention of EB1, EB2, EB3 High Skilled Immigrants. And that is what created the 485J supplement form. That is what kind of codified the regulations that AC 21 created. And so even DHS recognized that AC 21 was meant to make things easier, was meant to keep workers in the US. They called it retention of high skilled workers. Why is it now all of a sudden DHS thinks we need to send everybody outside the US? Now, there's a line in the policy memo that says USCIS acknowledges that there are exceptions, including non-immigrant categories with dual intent. So obviously talking about H-1B and L-1A, L-1B, H-4, L-2 holders, making it sound like maybe this memo doesn't quite apply to H&L holders who are adjusting status, and they don't have to worry about showing these discretionary positive factors. But at the same time, there's this footnote at the bottom that says maintaining lawful status in a dual intent category is not sufficient on its own to warrant this favorable exercise of discretion to allow for adjustment of status. So for people who are in H or L categories, do they need to worry about this memo? Do they need to do anything different?
The only thing I would possibly do different, Emily, and I think we talked about this kind of in our first reaction video on Friday, is, and it's going to make my stomach hurt saying this, but maybe right now we maintain our non-immigrant status as best as we can in case there is an issue with the I-485. That way you don't, have this, we need to leave immediately kind of issue. I would still file an I-485. I would still expect an adjudication. Maybe I throw in some evidence about, positive discretionary factors, show why they're a good person, ties to America, they've been working, paying taxes. Maybe I do that and a short brief on it, but I wouldn't, I had a consultation today. I'm not going to not file for adjustment. And just wanted to back up for Emily real quick. You talked about all the regulations. I pulled USCIS's policy manual on Friday. It was last updated, the adjustment of status chapter, last updated May 8th of 2026. They go through a history of adjustment of status, and it says one reason Congress created the adjustment of status provision was to enable certain aliens physically present in the United States to become LPRs without the incurred expense and inconvenience of traveling abroad to obtain an immigrant visa. And then it goes on to explain why it's a good thing. And so, for our H&L holders, my first thought when I read through it was, oh, they'll be fine. And then, you actually pay attention to the footnotes. And it does apply to them. But I have to think, Emily, we're going to see this apply more towards other categories, really. Maybe if you came in on ESTA or a B visa than anything.
Yeah, I agree with you. At this point, we're not doing anything differently. We're not stopping filing 485 applications for those that are already pending. There's no additional action to take at this moment. If you have an interview scheduled, you may want to consider being prepared to discuss these positive factors and having documentation with you for that. Otherwise, there's not really anything extra to do for your 485 that's already pending, except wait and see how adjudicators actually respond to this, if there's going to be any kind of response. And the other thing that I think seems a little ridiculous with this plan, how many green cards are issued through the adjustment of status process? It's about 500 to 600,000 per year. The majority of employment-based green cards are issued through adjustment of status, whereas the majority of family-based are issued abroad. So if we're taking 500 to 600,000 adjustment of status applicants and making them consular process, there is no way that consulates have the capacity to handle that many interviews. They don't have the officers, so we're going to have to hire a bunch of more consular officers overseas, not in the US. We're not creating US jobs here, in order to handle this, on top of the fact that for most employment-based applicants, all of their filings have been with USCIS. USCIS is in the best position to look into their immigration history and determine whether they are qualified for their green card or not. Consulates don't have access to the same level of information that USCIS does. So again, for those that are getting ready to file 485, I would say file it as usual. This is particularly for those in the employment-based categories in HRL status. Otherwise, we need to just wait and see. Wait and see how this plays out, which is going to be through requests for evidence, through notice of intent to deny, potentially denials. Once we start seeing those, then we'll know how exactly USCIS officers are going to be adjudicating these applications and what changes may need to be made going forward in our filings. How about the Department of State announcing last Friday, I believe, quietly, that they ran out of EB2 green cards for
Yeah,
India
I
or
thought
for
that was
everybody. Hold on. Yeah, for India.
for India for EB2. I thought that was interesting, Emily. I was just kind of looking at some visa news, and I saw this and I was like, maybe I'm looking at the 2025 link. Like that just seems weird. No, the Department of State has said it has hit the annual limitation for EB2 India. It was published on Friday, and that the annual limits reset October 1st, like we all know. It's funny because I texted a colleague, a friend of mine, and you had the same reaction, Emily, about the quarterly.
Yeah, so it is specified the number of visas, immigrant visas that consulates and USCIS can issue each quarter so that they don't run out early and so that they don't end up with unused visas at the same time. So if they're following their own guidelines and only approving that number per quarter, how is it we're in May and we don't have enough visas to last us through September? On top of that, they recently also shared the number of green cards that we have available finally for this fiscal year. So we have 46,000 extra green cards in the employment-based category that are created from unused family-based green cards from last year. So that means that EB2 gets a total of 53,000 green cards instead of the usual number. And even with those extra, they still run out for India. So what does that mean for people who have a pending 485 right now?
Yeah, I mean, what we should see is similar to what we saw when we've seen, the retrogression from, I guess, the June anyway, and then 2022 we saw a retrogression. You'll probably see a case remains pending status. You can still apply for your EAD and advanced parole. They're just not going to touch your 485. Now, if you have an RFE, like, still respond, right? That doesn't toll any of those deadlines via biometrics and RFE and interview, any of that. Like, it's not gone. They just can't approve your case. Now, we might see some here or there. I know anecdotally, and I don't have too much to officially back this up. Sometimes they're about to approve a case and they've gotten a visa number before they approve it. So we might see some trickle in over the next week or two. But outside of that, it's I wouldn't expect huge numbers.
All right. And so for the month of June visa bulletin, where we're using the final action dates, if you were planning to file, you can still file. The entire month of June is still available to file. It's just for those with pending 485s, they won't be adjudicating any in the EB2 India category. That will open up again October 1st, 2026. Do you think the data is correct here of them running out? Have you requested any particular data on
I will
this?
tell you, after I spoke with you on this morning, I quickly filed a Freedom of Information Act request. Just all data pertaining to EB2 India for this year, when adjudications occurred, how many priority dates, and all that. I'm not saying I don't trust them. It just seems very odd that this time of year we're using all the numbers, and maybe they've gone above and beyond and just super prioritized. I think it goes against the quarterly. I think this is the earliest we'd see a category unavailable. So maybe they just got super efficient. I don't know, but I think it's worth. I filed a FOIA. Took me all 10 minutes, and we'll see what we get out of it, because I just don't know if that. I'd like to see the data to support it. Trust but
All
verify,
right.
right?
Yes, exactly. Especially with this administration. And as Stephen said, you can still get your EAD approved, your AP approved. You can still file renewals for those if you need to. So all of the interim benefits processing is the same. You may still receive RFEs during this time. You may still be called in for an interview this time. So do all the things that you normally would do. The only thing that can't happen is the approval of the green card until October 1st at the earliest. If your date does become current on October 1st and you've been waiting forever, that is the time to consider litigation rather than waiting around for these dates to go forward and backward again and again. Because we all know that when there are so many pending 485s, they don't seem to be really processing them in any kind of order based on first in, first out, or based on priority date. They just grab random files and start approving people that filed way later than people who filed earlier. So litigation can help with that. But let's move on to the H-1B lottery numbers came out. Now,
Sort of.
USCIS claims that the data that they've shared clearly shows that there's no more abuse of the program, there's no low wage positions, and it's better serving its intended purpose of attracting highly skilled foreign workers. Do you think the drop from 343,000 registrations last year to 211,000 registrations this year is because they've rooted out fraud and abuse?
I think there's a number of things, Emily. Like let's talk about the whole situation around what's going on right now. We know there's $100,000 proclamations. So vast majority of companies who sponsored from overseas probably didn't do as many registrations or any. Some I know some did, and they kind of will wait and see what happened. But we know that is drastically cutting numbers from overseas. Um, we know that some companies are doing layoffs and might not be that might have done more in the past, might not be doing as many or any this year. So that's a factor. And then, kind of have some general sentiment around how the administration is treating these workers and employers. And so, I don't think that necessarily the new wage power ranking is what I call it, regulation changed how many people did registration, which is really the only change that's happened to the lottery itself. I just think it's kind of all the number of factors that went to it.
Yeah. So they also claim that this year, 71% of those selected hold a U.S. master's or higher degree compared to 57% last year. And I don't think that necessarily means that the whole pool is, there's more master's people. I think it means that we cut out people applying from abroad. So the majority of people who are not subject to the $100,000 fee are those that are in the US in F1 status. And so those tend to be people that have master's degree. The other probably top groups of people that filed this year are people who are on H4, people who are on L1 or L2, people who are on TN, basically anybody who is in another visa category, because only those people are not subject to the $100,000 fee. So I don't know if they've really done anything different with the lottery, with these wage level things. They have to come out with the data, tell us how many they selected. First of all, they only told us how many registered. They haven't told us how many they selected. We won't know how many petition filings that results in until the end of June. And then they didn't tell us, what percentage of those were level 4, what percentage were level 3, what percentage were level 2. Like, how did the requiring that wage level information changed the lottery. They did specify that only 17% of selected registrations were level 1 wages, but that didn't tell us how many registrations there were that were level 1. So I don't know. I think they're kind of tooting their own horn here with these numbers without actually sharing the real numbers that we need to determine whether they successfully did whatever it is what they were trying to accomplish through this new lottery system.
Yeah, and I know a lot. I talk to a lot of immigrants. I do some guest work on a podcast. That hey, getting more people who are on student visas, that's a good thing. And it's not my place to give I have a lot of different opinions on policy. Maybe if that's the goal, but I don't think the only thing they've done, is the $100,000 and the new regulation, and none of those, I think, targeted fraudulent bad actors that we always talk about.
All right, last update for this week. USCIS kind of without any advanced warning issued an interim final regulation. It's in the OMB stage, meaning it's submitted to the Office of Management and Budget for their kind of first pass at it. So it's not published yet. We don't know what's in it yet, but it appears that USCIS plans to make electronic filing for everything mandatory in the very near future. What are the problems that you've experienced with their electronic filing up to this point, and why do you not file electronically unless you absolutely have to?
Yeah, so you have two ways you can go about filing, and let's just talk I-129 online. That's going to be for like extension H1s, L1s, all that. Like number one, you have two ways to do it. You could do the data entry of all the information, or you can upload a PDF. Well, their PDF reader is still not great. You've got, if you have ABC, comma, Inc., period, but the online portal shows ABC Inc. with no comma, no period. They're going to make you change all the forms. You can't list the G28 signatory, which I don't understand. And it still takes, if you do the PDF upload, they still say it could take up to 30 days for them to quality control check it and issue a receipt number, which is ridiculous. The data entry one, is not as bad. The problem is there's not peek behind the curtain. Every attorney out there uses some sort of form software to help them draft forms, whatever it is. None of the USCIS systems talk to any sort of software. And so it's kind of a pain. And then you still have, when I do digital, even the data entry, I have to get my company client to get on and digitally approve everything. So we had an issue in our office where somebody was trying to do that, and the signatory was on vacation. The person with the My USCIS access was on vacation, or what if they're sick? So, right now they can send you the signature pages and let you use them, saying, hey, I'm ready to file Emily's case. Here's the signature pages. So I still think there's a lot of flaws. It's just not a great system. I think if they actually put the effort into making it a system, that there's a lot of positives about it if it worked, properly.
Yeah, I think there's a lot of limitations in uploading evidence. You have to organize it in a certain way that might be different than what you're used to with the paper filing. It has to be in a certain format. There's limitations on the size of different files, how you label it, how you make exhibits, all of that is problematic with this online filing. And then just the forms themselves, like the limited use we have of them, just as an example, and this isn't even a form that attorneys have access to, but the I-539 form. So we work with a lot of clients who file the I-539 form online themselves, but they work with an attorney to review the form before they submit it, because attorneys do not have access in our own My USCIS accounts to file an I-539 on behalf of someone, which makes no sense as well. But just in that, there's a drop down where you have to enter what your current immigration status is. And still, in May 2026, there's no option for H-1B, which is a large portion of people filing this form. It says H-1B1, which few people are in. That is technically a different status. It's like their forms are just designed so terribly. I mean, even the paper forms are not designed well, but at least I can handwrite something in or type it's a free form. But with these, everything's a drop down and not all of them work properly. And I think when you combine this with the fact that they went to the ACH payment issue in October, now they have published this final rule about accepting signatures. They have to be copies of the handwritten wet ink signature. And the fact that most people are not using the online filing system, I think this is their way of forcing everyone to use the online system so that it clears up a lot of the problems they're having with the ACHs and the signatures. I mean, every single day we receive files back from USCIS because a payment didn't go through, whether it's on the ACH form or the credit card form. We would submit the exact same form 10 different times in 10 different cases. 9 of them go through fine. The 10th one gets rejected. No idea why. And USCIS has to mail it back to us, and they send it in like 3 separate packets. So for just one case that we got back today, USCIS has spent at least $5 in postage on 3 separate envelopes and still hasn't even sent back the I-129 that they rejected, which is going to be another $10. I can only imagine how much money they were wasting on postage due to these ACH payments not going through and paper filing. So I have a feeling that is more than anything what's triggering this mandatory requirement to go to online filing. It's going to be a pain in the butt. I hope they're improving their systems before they actually make it final. But that's kind of what we're in for going forward.
And we're not the only ones getting these rejections. I mean, it's all based off of the ACH. But I remember a couple weeks ago, I went to go file a case online, and I went to go upload the H-1B selection notice, and we just had to do it because of, like you said, all the ACH issues, and the cap gap was needing to file really quick. And I downloaded the selection notice from my USCIS, went to go upload it, and it said, "Oh, this contains foreign language characters. You can't use this." I'm like, it's the USCIS I-797. Like, what are you talking about? Well, I talked to one of our other attorneys after I just uploaded a memo explaining, like, I can't upload what you want. Like, you guys figure it out. That said, sometimes with the way the document is titled, like if you've got a hyphen or like whatever, a comma, something in there, it triggers that. So it's just, not made by the best development team out there. That's for sure.
All right. Shall we head to some questions?
Yeah, let's hit some. Lots of them today.
All right. Lavanya says priority dates May 2014. The primary applicant got an RFE for just the medical, but the spouse got an RFE for the medical and documentation of the marriage. Wants to know, should the primary packet also include the marriage evidence too, or just the medical? So the reason the spouse got the marriage evidence RFE is because only the spouse has to prove they're married, because that's how they're qualifying for the green card. As the main applicant, you can qualify for the green card whether you're married or not. It doesn't matter. So you do not need to submit medical evidence with the main applicant because your case does not depend on your marriage. It's based on your employment offer.
Question here: is it normal for USCIS to send medical RFE with a 1-month deadline? I received the RFE today with a response date of June 23rd. I have to double check. That doesn't seem too abnormal. I think they're usually the 87-day, but just get into an appointment real quick if you can.
Bishan says, got laid off on H-1B with 2 years left towards the 6-year limit, no I-140. My wife is on H-1B with an approved I-140. Can I move to H-4 and then come back to H-1B after I find a job? Is the $100,000 fee applicable? You can move to H4 and then move back to H1B. The $100,000 fee is not applicable as long as you're maintaining your H4 status and file it as a change of status from within the US. The $100,000 fee only applies to consular processing petitions where you're outside the US at the time of filing or not maintaining your status. Now, the issue is you may have to wait for the H4 to be approved before you can file the H1B. In the past, we were able to do it based on a pending H4 or a pending B2. That doesn't seem to be the case anymore, but you are not subject to the $100,000 fee, and you don't have to go through the lottery again because you've already been counted and have not used your 6 years.
Question here on YouTube: what's the cost process for green card EAD litigation? Can we actually litigate those? Yeah, I absolutely think we can. These interim benefits, the EAD and the advance for parole would kind of give quasi green card benefits. And, going from October where yours is, that's way too long. These forms, I'm like, take like 15, 20 minutes to adjudicate. Like, I think that's too long, right? Because the question is, do you have a 485? Mm-hmm. That's it. So yeah, feel free to reach out to our team, info@rnlawgroup.com, and we'll get you the information on that or get you over to me.
Neil Mania says, I have a 485 pending. EAD and AP are valid till November 2029. Company is filing the H-1B extension of status due by October 2026. Should I pay premium processing fee for the extension? I would. Although you have 6 months to get the approval, current processing time is posted at like 8.5 months for an H-1B extension, and they're just getting worse and worse every day, every month that we wait. And with this new AOS memo, we don't want to get into a situation where after your H-1B I-94 expires, you get an H-1B denial, putting you out of H-1B status. Then you have to rely on your 485 only. And then with this new memo, who knows what's going to happen with this discretion. So I would, in that situation, just pay the premium processing fee to get it over with, get the answer before your current I-94 expires.
Question here from YouTube. Emily, my I-140 is still pending more than 2 years in regular processing in EB1C. What should I do as my company won't do premium? Unfortunately, as the beneficiary, there's not a lot you can do. You can't talk to USCIS. You can't do a service request on your behalf. I guess theoretically we could sue because that's insane and you have standing as the beneficiary. But premium's usually the better route to do that. The one positive, you need CISPA. 2 years is you're going to be able to subtract 2 years. That's a little abnormal, for sure.
Yeah. Krishnavani says, I'm currently in AP EAD, not maintaining H-1B status since 2022, received an RFE for medicals and supplement J, and wanted to know how the May 21st policy memo could affect the adjudication of the 485. My personal interview was already completed in 2024. We don't know, unfortunately. There's a chance that you get an RFE or a notice of intent to deny saying that, we plan to use our discretion to deny your 485 because 485s are discretionary and we need to see the positive factors to determine whether you qualify for adjustment of status in the US. That's a possibility. That's also a possibility that because you were an H-1B holder when you filed the 485, that they will take that into consideration and not do anything related to this memo. I wouldn't take any action one way or another. I would just be prepared for an RFE, be prepared maybe for another interview and plan to bring documentation of your positive discretionary factors. But beyond that, there's nothing I would do differently at this point. We have to wait and see what other people get in terms of RFEs, notice of intent to deny, any denials that we receive. That's what we're going to learn from, unfortunately, because they're not going to put out additional information beyond this policy memo.
Yeah, keep in mind, right? So this memo was published Friday morning. It was a holiday weekend. I don't think many of the line adjudicators were like prepared and trained ahead of time. Nobody worked yesterday. Um, I mean, I don't think we've seen any decisions that were made yet since Friday. We're going to have to bob and weave as we see things, as we hear from people, other attorneys, as we hear from people on in our network, as it goes, and we'll provide those updates as we get them because we're learning too on this. This is new. A question from YouTube: if the H-1B extension is filed using premium, will the dependent H-4 be approved once the H-1B is approved? So I will say I've actually seen fairly decent trends of concurrent or semi-concurrent processing of the I-539. It's not all of them. Some of them do get separated out and still have delays, but in all of the EAD litigation I've been doing, Emily, like the vast majority are EAD only because the H-4 got approved fairly timely. So it's not a guarantee it'll be done in premium or even the next week, but I'm seeing some pretty good trends on the I-539.
Alzen says, is it possible to renew and recapture an H-1B visa, even if it's been more than 6 years? I've been offered a job by the same employer. Yes, so there's no requirement that you have to recapture unused H-1B time within the 6 years of when you got that H-1B. That was specifically stated in the 2017 regulation that I was talking about earlier. So you can use that remaining 4 years, 10, 20 years from now. It does not cut off. You have that time to reuse forever. Now, you also mentioned you're planning to enter on a B1, B2 and then file a change of status. That could be problematic because right now, in the proclamation of the $100,000 fee, they specifically mention that they don't want people to be issued B1, B2 visas and then enter the US and then file a change of status to H-1B in order to avoid the $100,000 fee. So that could be problematic. But if the $100,000 fee goes away, you can definitely get that time back through a consular processing petition. And it doesn't have to be with the same employer. It can be with any employer.
A question from Priya on Facebook. My family applied I-485 in February 2026. Should we submit any additional documents or a letter in the unsolicited section of USCIS to back up the latest USCIS memo? If so, please advise a template. I'm not sure if I would submit unsolicited evidence, now that you've already filed. I would maybe consider filing with something if you want to, but my position is I don't think they can just deny these. I don't think there's a way they could, just deny every 485 today saying you don't have positive discretion. There would have to be some sort of opportunity to respond, whether it's a RFE or notice of intent to deny. So, would it hurt to put in unsolicited advice? No, I just don't know if it's necessary right now.
Chinjin says, I'm India-born Canadian citizen, been on H-1B for 18 years. If my son applies for the green card for me, can we apply in Canada? And if we do apply in Canada, after applying, can I come back to the US on a visa? So for family-based, you do have the option of maybe avoiding all the mess with this 485 policy and just having your son file the I-130 petition for you, mentioning that you will consular process. You can be in the US on H-1B status the entire time that that I-130 is pending. And then once the I-130 is approved, it'll then be sent to the consulate in Canada for you to go for your interview. So you can stay in the US that whole time and then just go to Canada for the interview. And usually you'll get your passport back with the immigrant visa stamp in it so that you can return back to the US as a green card holder. You wouldn't need to come back on the visa, and you wouldn't really, apply while you're in Canada and then come back into the US on the H-1B. All of this can be done while you're in the US, and you just wait in the US until your interview at the consulate. Of course, this is assuming you're maintaining H-1B status. But yeah, you can definitely do that.
Emily, you did just mention something we didn't talk about in the top. We talked about how we would change things. I think the one thing I would be sure I was doing right now is any I-140, I-130, I-526, market for consular processing. So let's explain why real quick. When you file these forms, you can mark whether you want to do consular processing or adjustment of status. Guess what? You're not bound to it. But if you mark adjustment of status, for whatever reason, they don't send the form then to NVC with Department of State. So if you decide, I'm going to consular process my green card, you have to file an I-824, which costs money and takes like a year and a half for them to send an email to NVC. I kid you not, it's an email. And by marking consular notification on the I-140, 526, I-130, they will automatically send the file to NVC. Guess what? You can still file for adjustment. So that would be a change I would make. Question from YouTube. I have an I-485 interview scheduled for 6/22. My wife's name's not included in the interview. Can I take her with me? I think most of the times they do recommend bringing the spouse. I don't see any reason not to. I mean, worst case, they'll tell her to wait in the lobby, and that's, kind of a waste, but I would bring her. They might have just forgotten to include her. The field offices aren't always the best organized.
Krishna says, while being on H1, can we apply for an H4 and H4 EAD with a future date, like 1 year into the future because of H4 delays? You can definitely request a future date, but it's not necessarily always honored. And I don't think you can request it 1 year in advance, even though processing times could get close to a year as we continue in the Trump administration. So 6 months is probably the furthest I would put as a future start date. Otherwise, you just let it take effect on the day it's approved. So if it takes a year, then it'll take effect 1 year from now when it gets approved. The main issue is if you get the H4 approval and not the EAD, because then you won't be able to work. But most of the time they are approving them together. The only issues now are with the EAD biometrics. That does slow down the EAD processing time. So you may want to file, if you're filing it with an H1, file it in regular processing first, wait till the biometrics are done for the EAD, and then consider upgrading to premium and see if you can get all three approved together to avoid those issues.
Question from Rahul on YouTube. My priority date is July 10, 2014. My employer has not filed my 485 yet. They're still planning to file it this week. Is it too late? Is it okay if they receive it, or should a receipt be generated? Man, they better get it in quick, because Visa Bulletin goes backwards, and I think they're using the date of the final action date chart for June. I actually think they are for May as well, so make sure you're there. But I know it retrogressed in June, so if you're still current for May, get it in ASAP.
A couple of people ask if the 485 memo applies to marriage-based applicants as well. Yes, it does. It applies to all types of 485 applications. So regardless of whether you're employment-based, family-based, marriage-based, anything else, it is discretionary whether they're going to let you adjust status versus consular processing. We are not sure if the determination is going to be made based on your underlying non-immigrant status at the time of filing and how you entered the U.S., or if this is just a big, all for show and nothing's actually come of it. We'll have to wait and see, but it does apply to all types of adjustment of status.
Question from YouTube. Any updates on the litigation for automatic extension of EADs? None yet. We have continued to allege that in a lot of our H4 EAD lawsuits where the H4 is already approved. Knock on wood, those individuals get a decision before we have to get there. And unfortunately, I think, that's the best interest of them. But I know there's one case going on in California. I think I saw another one get filed not too long ago. Looks like there's a hearing the end of June on the one in California.
Tejas says, my perm is approved last week in EB2. My priority date with the previous employer is October 2016. New employer's about to file the I-140. Do you suggest premium processing? It's definitely not mandatory since your priority date is not anywhere near being current in EB2. So the biggest question would be, how safe is that job? Do you want to get that I-140 approved and in place before anything happens to the job? That may not be as big of a problem since it's not your first I-140. You already have an I-140 that you can use from your previous employer to get H-1B extensions and get H-4 EADs for your spouse. So it is really not mandatory in most situations.
Oh, question, Emily. EB3 AOS filed. With all the people that have gone upgrade, downgrade, backwards, forwards, all that, with going back to October 2020, if they think they did the last one as EB2, now it's retrogressed, it's unavailable. Let's say they're current under EB3. Can they transfer their bases back to EB3? I would say you can.
Yes. Yeah. So you can go back and forth multiple times, but you do have to submit it in writing every time. And there's no way to really know what category they consider you to be under. So the best thing to do is just submit another transfer of underlying basis whenever your date is current in a different category. Vivek says, I received my EB1 green card, but my wife has an interview coming up. She's a derivative. In light of the new memo, how should we prepare differently to be best positioned for success? Yeah, that's a tough one because we don't know exactly, what officers are being trained on, if they're going to be doing anything different at an interview now compared to what they would have done a week ago. She should be aware of the memo and what it says, and I would probably be prepared to bring documentation of those positive discretionary factors. So that's going to be length of time in the US, payment of taxes, community ties, family ties to the US. The USCIS policy manual does have a pretty long list of things that they consider to be positive discretionary factors, and you're not limited to just those factors. If she's working in an important job, something that, helps the community or helps the economy, you can include all of that. So there's a lot that she can prepare and just be ready to discuss it. But we don't know if it's going to actually be necessary, but always best to be prepared.
Vinay on YouTube asked, my H-1B stamping has remained under 221G for the past 10 months. What to do? So, not surprised. We've had a lot of cases go into administrative processing, 221G, and they just it is literally a black hole. We have brought some lawsuits on these, but these lawsuits aren't the easiest because of how courts view what 221G is. Some view it as a final agency action, and therefore there's consular non-reviewability, so courts can't get involved. Some say, no, you can't still be processing something and call it refused. I'm happy to set up a call to talk about that, but it's not, as cut and dry for things.
Tian says F1 for 6 years, H1B for 6 years. Just because of this policy memo, I'll be rejected for AOS. I paid 7 years of taxes. My life has been centered here for 14 years. My wife is a US citizen. Unfair. Yeah, I completely agree. As Stephen said earlier, adjustment of status is the long-standing method of receiving a green card if you are in the US and lawfully maintaining your status. There is zero reason to force people who are in the US to exit in order to complete the green card process through the consulate. Zero, that does not advance any policy, anything beneficial to the United States. All it does is make the process harder for no reason. Again, we don't know that your AOS will be rejected. This might just all be for show and not actually impact people. We're just preparing but we have to see how it is actually implemented in the field with the day-to-day cases.
Yeah, because it just doesn't say we're not doing green cards. It's just saying we're going to close this one procedure. So I don't know. Emily, I saw a question on here about guy having issues with his Texas driver's license. He has an approved I-797 now. You're an expert on this last week, right? Yeah, you did. Had to dig in and do some research on Texas driver's license law.
Yeah, so there is a Texas administrative law that is not related to proving your lawful status in the US, but for you to be able to prove your identity, you have to provide your foreign passport, which is valid, and then a copy of your visa stamp, which can be either valid or expired according to the actual text of the Texas law. So you can have a valid passport and an expired visa stamp and still be able to prove your identity to be able to get a Texas driver's license. In reality, they give out this little brochure that says that the visa has to be valid, unexpired, which is not what the law says. And on their website, one place says that your visa needs to be valid, even though that's not what the law says. So there are, people at the DMV who are incorrectly denying based on probably instructions they got from supervisors because of a poor reading of immigration law. This is yet another reason why states should have no business enforcing US federal immigration law because it's so confusing and complicated. They don't know what it is they're looking at. So yes, you can have an expired visa stamp in your passport as long as you have a valid I-797 approval with a valid I-94 and a valid passport. You should be able to get your driver's license. You may have to talk to a supervisor. We are trying to find a contact at the state of Texas DPS to reach out to them to let them know that they are not following their own laws. So that might take some time, but technically you should be able to get your driver's license.
Yeah, it's kind of funny to see them not file. Like, what is the law? For sure. Question: have we seen any updates on visa slots in India? No, I have not. I'm trying to avoid travel, right? If you're on a non-immigrant visa, especially having to go to Mission India, I am avoiding travel unless really have to. It's just kind of a mess.
Viraj says, what about traveling outside the US on a travel document, advance parole? Do you see any concerns? Maybe, again, it is too soon to know what is going to happen to those with a pending 485. But in the worst case scenario, what if you travel outside the US planning to use your AP to return, and while you're out, your 485 gets denied under this new discretionary policy? Now, I would think that they would give you an RFE or a notice of intent to deny first, giving you the opportunity to provide those positive discretionary factors. But what if they don't and your 485 gets denied while you're outside the US, you don't have a visa stamp, you were not maintaining your non-immigrant status, now your AP is gone. That's the risk that you are running by traveling on AP right now without us knowing exactly how this memo is going to impact you. So you really have to think about, is your need for travel important enough to be willing to take that risk, which we don't know if it's a big risk or a small risk, because we don't know exactly if they will deny a 485 without any RFE first for someone who's already filed under this policy.
Question on YouTube: does my dependent also get cap gap if I'm on F1? Get cap gap until September 30th. So first off, cap gap's now until April 1st of the next year. The other thing here, the cap gap is really the work authorization more so than the status. So you don't need it, there's not, I don't know, there's not a cap gap for the status of the F2 spouse, but you'll be fine.
John says case was at NBC in April, moved to the field office in mid-May, and now today it's back to the NBC. When does this happen? Could be because of this announcement of the unavailability of EB2 India green cards. I'm not sure if that's your category or not, but it's very possible that you're put it in that case remains pending category because a green card is no longer available, so that they don't need to interview you yet. Or it could just be inefficiency, could just be that the local field office did what they needed to do and sent it back. There's just no way to know. And it could be completely inefficient or it could be on purpose. And there's no way to know that either.
I like this question here from YouTube. Are K1 visa entries affected by this memo? And so I would say arguably yes, but, and I say that because yes, it says non-immigrant with dual intent, are not like excused from this memo, for lack of better words. But I think this is a funny example, Emily, because Congress goes ahead and creates this whole non-immigrant visa category called K1 to allow, fiancés to come in, get married, and adjust status. Like that's the whole thing about K1s. And so, while Joe Edlow's out there trying to gaslight us that this is a loophole, we've got a whole visa category designed for adjustment of status.
Yeah, this whole thing just makes zero sense.
I just hadn't even thought about the K1 until I saw that, because again, they created a non-immigrant visa to allow you to come in, because otherwise you'd be stuck having to wait for consular processing, which might be 2 years. But they created this non-immigrant visa so you can come in, get married, 90-day fiance, right? And adjust status. Like, what are we doing here, Joe? Gar asks, can we sue them? I assume you're talking about the memo. I can tell you there's a lot of brilliant minds, even more brilliant than I am, that are talking about this. I've been talking to a lot of attorneys about this. It's not, there's a lot of tricky parts to this, right? So you don't have a final agency action, so you've got to talk about theoretical harm. Then we're talking about adjustment of status. Well, there's a section of the Immigration and Nationality Act that creates hurdles to jurisdiction when it comes to adjustment of status challenges in court. Now we've got a policy, not a specific adjustment of status, so that makes it a little easier. But who's harmed? There's all these wrinkles that have to be thought through. I think there's good cases that can be brought. I just think it's a lot different than we can bring it tomorrow because it's super easy. I think this is going to require some nuance to it.
Jyoti from Facebook says, how long is the perm process taking nowadays if an employer starts the green card application now and the employee already has an I-140 approval with the previous employer? Assuming you're going through the perm process, it's planning on 2 years. It's going to take at least 3 months to get a prevailing wage determination. That's once the job details get finalized, which can take some time. Once you have the prevailing wage, then it can take up to 6 months for the advertising process, the recruitment phase to go through. And then the perm is filed, and they're taking 17 months to adjudicate perms right now, assuming there's no audit or RFI.
Let's see here. Sorry. What is the prediction for green card dates for 2016 November? You're talking to the wrong people. Emily's somewhat is somewhat good at the math and can kind of make some guesses, but I think that's all it is we have to take a lot of variables into consideration, and we don't even know how much spillover there is for fiscal year 2026.
Ooh, it just came out, yeah.
Oh,
last week.
Sorry,
we do.
I lied. We'll have that next week. Little teaser.
Yeah, it is. Where did it go? 46,000.
Okay, so decent.
We have 186,000. Yeah. Let's see. We have time for maybe one last
Suresh
question.
asks, I like this question from Suresh. I think it's a good closing question here. Does the adjustment of status proclamation affect green card holders that already have it in case they're traveling? So I would say I have this doomsday, the world is ending theory that it could. But I would say there's a lot of things that would have to go wrong for us to get there. I really do think if you have a green card, this has zero impact on you. And if that changes and we get to my end of the world scenario here, we'll go live immediately. But I don't think it would impact you if you're a green card holder.
All right, well, we are out of time for today. Thanks everyone for joining us. We'll be back next Tuesday at 5 o'clock Central Time. In the meantime, if you want to set up a consultation to discuss any of your specific case details with us or any of our attorneys, you can go to rnlawgroup.com in order to set up a consultation.